as I say, welcome everyone to the latest in our People Matter series. So just to introduce ourselves, my name's Kate Ledwidge. I'm a Principal Associate in the Employment Team at Mills and Reeve. Emma, I don't know if you want to introduce yourself.
Yeah, I'm Emma Williams and I'm a Senior Associate in the Employment Team.
So as you'll see, today we're going to be talking to you about getting disciplinary and grievance hearings right. First, just a plug for the next webinar in this series, which is the piece after the hearings, which is appeals. That's going to be presented by our colleagues William and Ramsey, and that's on Wednesday the 13th of March. So do log into that one as well. And so this session is being recorded and it will be available afterwards. I think it will be part of the follow-up email you get, including slides. So you don't need to worry about taking copious notes. You should be able to watch it back if you need to. As I say, we're going to try and leave a bit of time for questions if we can, albeit the schedule's quite tight. So do feel free to pop questions into the Q&A box. We'll get to them if we can. If not, it might be that we can answer them sort of as follow-up as well. And just a request, if you could please give us some feedback at the end. You'll receive a form. We'd really appreciate it. Any suggestions, comments, topics you might like to hear from, it's all really helpful for us. So please do feedback on that. So just a quick recap. The last webinar in the series dealt with investigations in a lot more detail. So you can go back and watch that. A recording is available on the website if you missed it. So it takes you through investigations in a lot more detail. But today, what we're going to be dealing with is the next phase, which is the hearing in a grievance or disciplinary process. Those are the key topics we're going to be covering. Starting off with Emma, who's going to talk to you about the role of HR.
Thanks, Kate. So yeah, before you really get into the detail of the hearing, it's always helpful to make sure that everyone involved has got clarity in terms of the roles that they have. So before I go into the role of HR, it's probably worthwhile reminding ourselves what the role of the panel is. And when I reference the panel, that is ultimately the decision maker. So it might be the case that your decision maker is just one individual, but sometimes it will be a panel. So if I reference the panel, it's ultimately whoever the decision maker is. And of course, the panel are involved in terms of asking and answering these two questions. So first of all, are the allegations supported by the evidence? And then secondly, if so, what is the appropriate action? And a lot of the time, we do see that these two questions are conflated, and that often confuses matters and actually makes it a lot harder to then explain to the employee why they are being subjected to disciplinary action or why their grievance is or isn't being upheld. So it's really important to get it crystal clear that these are two distinct questions that require two distinct answers. And ultimately, it is going to be the panel that needs to make that decision. So it's not for HR to be involved in determining the outcome to those two questions. It must be the panel. And the reason that's so important is ultimately, if you find yourself in tribunal proceedings, you're before an employment judge, it will be the panel that will be required to justify why they reached the decisions that they did in relation to these two questions. So really important just to hammer that home that it's two separate questions to be answered. So in relation to HR, as I say, their job is not going to be to determine whether the disciplinary action is appropriate or whether the grievance should be upheld or not. The role of HR is more focused around making sure that they're advising on the law, process and procedure that's of course going to be relevant to these hearings. And that's going to be looking at the legal side of things, looking at the policies that you've got in place, and then if necessary, liaising with external lawyers around any sort of complex legal questions that might arise. So their role is quite clearly not to interfere with the decision. That is very much sitting with the panel, but to give that guidance and support throughout the process. One point to note is that HR advice won't be privileged. And what I mean by that is if there was a freedom of information request or a subject access request made by the employee, any communication between the manager or the panel that are dealing with the decision and HR will be disclosable. Likewise, if you end up in tribunal at the point that documents are to be disclosed, again, any kind of communication between the two will be disclosable. So it's really important to bear that in mind when you're firing quick responses to each other, whether that be via email or whether it be via Teams. And we have actually seen it play out in tribunal where there's been a real focus on what a sad face emoji means in the context of whether the manager was sad that an employee was pregnant and therefore was going on maternity leave, or whether they were sad that they didn't know and they wished that they'd found out sooner so they could have congratulated the employee. So it just shows that without context, those kind of communication pieces, especially over sort of informal platforms such as Teams, can really end up under the microscope further down the line. So in terms of what HR can and can't do, the slide sort of sets out some of those points that I've sort of referenced already, but just focusing on that point that HR should not give their opinion on culpability and their opinion on sanction. We have seen that play out again in the tribunal in the case of Ramphel and Department of Transport, where actually the decision maker was in front of the tribunal being cross-examined and was being asked to justify why he made the decision to dismiss the employee. And unfortunately for the manager, he was unable to justify it because actually it was HR that had overstepped the mark and said, instead of giving the final written warning, which the manager wanted to do, we think you should dismiss him. And therefore it ended up in his dismissal. So that inability to justify the decision by the decision maker rendered the outcome ultimately unfair. So it just really shows that sort of key difference between the roles of HR and the decision maker and making sure there's a clear line between them. And I'll pass back to Kate for considering adjustments.
Thanks, Emma. So as I'm sure you all know, one important thing to consider sort of early on when you're dealing with a hearing process are whether you need to make any reasonable adjustments. Say if an employee has or may have a disability, you do need to look at the practical arrangements for the hearing. Under the Equality Act, there's a specific duty and it can lead to a separate claim of its own. So it's important and we recommend considering that sort of right at the very start when you're first arranging the hearing. Obviously, if it comes up later, you still need to deal with it, but look at it early. The key legal question to ask really is whether any aspect of the disciplinary or grievance process might put this particular disabled employee at a substantial disadvantage when compared to an employee who hasn't got a disability. In practice, that means I think you just need to talk to the employee in question and ask them, you know, what are their particular needs? What are their concerns? What might they suggest you could do to assist them? If needed, probably in more complex or difficult cases, you might want to consider getting some occupational health advice on adjustments as well, but hopefully the employee will be able to, you know, articulate it for themselves. And then, as always, what's reasonable in terms of an adjustment is going to depend on the particular circumstances. The adjustment's got to actually alleviate the disadvantage that we're worried about. It's got to be quite practical, and you look at all of the usual factors when considering that. For example, what resources do you have available as an employer? But looking at some examples sort of reasonable adjustments in practice. So a very practical example, and I think anecdotally this seems to be coming up a lot at the moment, I would say. If you have an employee who is dyslexic and therefore has difficulty with reading documents, a good adjustment to suggest might be having a particular companion to help them to read any documents that they need to. It might be that they would like documents in a particular format, or they might need some additional time versus an employee without that disability to read and digest documents either before the hearing or during the hearing, depending on when it's needed. Some employers might allow a wider category of companions, so like a family member or a friend as an adjustment. Emma's going to come on later to talk about sort of obligations around companions in a bit more detail, but this might be considered an adjustment to sort of help someone say who's got significant issues around anxiety. And then a couple of recent examples from, a couple of examples from case law. This one's sort of relatively old, but there was an employer who sort of was said to have failed to make reasonable adjustments in respect of their employee who was deaf, who was going through a disciplinary process, which ultimately led to his dismissal. So it's a serious outcome. And the hearing was conducted effectively as a standard hearing, just a spoken discussion. And the employee just couldn't really understand what was happening and effectively was then unable to participate in the hearing. And the employer was found to have failed to make reasonable adjustments. They should have, for example, provided a sign language interpreter to help the employee. Now, that's quite an obvious one in sort of our understanding of reasonable adjustments. A more recent example, which I think is slightly less obvious, is the case of Hayes, Hayes, against Rendell and Rittner Limited. So, and this employee was ultimately dismissed for, some quite unsavoury disciplinary issues, really. The employer invited him to a hearing via Teams, which is quite standard, obviously, in our worlds these days. He didn't couldn't join the Teams hearing. So the employer said, fine, reschedule it, sent another link. He couldn't join again. He had been warned that if he didn't join again, then a decision might be taken in his absence. So that's what the employer did. They ultimately dismissed him. And he brought several claims, including a failure to make reasonable adjustments claim. His position was he had anxiety, coupled with a personality disorder. He'd never used Teams before, was very stressed, didn't know what it was, didn't know how to join. And the tribunal agreed with him and said the employer should have rescheduled the disciplinary hearing a third time, held it by phone, to allow him to participate. So it just goes to show how important it is to really consider reasonable adjustments and talk to the employee, I would say. So that's adjustments. You may find, this is quite typical, that an employee goes off sick, perhaps during a disciplinary process, for example, but we don't think they're actually disabled. So no duty to make reasonable adjustments, but there's obviously a duty to ensure you're following a fair process generally, so you still need to proceed carefully. In general, our advice is just pause the process initially and sort of take stock, gather some more information. Why are they off? When might they come back? What's the impact of any delay? Is there any urgency? Because that will be relevant. Usually not immediate urgency, and that's why it's sensible to pause it. Even if after a reasonable period, they are still saying the employee cannot attend the hearing, that's when you should consider either getting some advice from occupational health and or offering some alternative arrangements yourself. For example, if they can't attend in person, can they just provide a written statement or submission? Can the decision maker or panel ask their questions in writing and the employee replies in writing? All those sorts of adjustments should be considered before you ultimately get to the final stage, which is if the employee, after all this, still refuses to attend, says they can't attend, you'll probably get to a point where you need to just look at the case and come to a reasonable decision based on the evidence you've got. Very important to warn the employee that you're going to do this in advance, and then it's just a case of looking at all available evidence and coming to a reasonable conclusion. So, as I say, briefly touched on the issue of companions, but Emma's now going to look at this in a bit more detail.
Thanks, Kate. So yeah, when it comes to the actual hearing itself, of course, there is that statutory right for the employee to be accompanied either by a trade union representative or an employee. But as Kate's mentioned, there may be scenarios where you go beyond that, and that might be because the employer's policy actually permits anyone to bring perhaps a friend or a family member or it might be in those sort of exceptional circumstances where there is that adjustment that is being made, where someone other than the trade union rep or colleague actually attends with them. Whoever that representative or companion is, it's always worthwhile setting out quite clearly before the meeting starts what the role of that individual is. And the reason for that is to make sure that everyone's familiar and understands what the purpose of the companion and their presence in the hearing is. But also in that sort of rare occasion where you may encounter some difficulties with the companion, you are able to refer back to the point that you made from the outset in terms of the scope of what they can and can't do in a meeting. So as we've got on the slide, of course, the representative is allowed to put the employee's case forward and sum up their position. They are able to respond on the employee's behalf and, of course, confer with the employee. However, there's no right for them to answer questions that are put directly to the individual, nor are they able to act without the employee's express wishes. And they can't act in a way that curbs the employer or any other person that may be sort of relevant to the hearing. One point to note, given that sort of move that we have had in recent years to hearings taking place on Teams or any kind of equivalent video platform, is you want to make sure that there is that facility for the companion to liaise with the employee during the hearing. So whilst traditionally you probably would have allowed them to just have some time in the room, you would step outside if you were HR or the decision maker, and you'd give them that privacy to talk. Of course, if everyone's joining from their own laptops in very different places across the country, it's harder to see how that would work in that sense. So it's again probably worthwhile from the outset of the hearing making it clear how it should be communicated from the employee or the companion that they would like some time to discuss, and just agree some arrangements on how that would work. So it might be that everyone leaves the Teams conversation and they have a phone call separately and then everyone rejoins at a specific time, or whether it's a case of people just going cameras off onto mute and then them having that conversation in private, which is of course the key thing there. Whilst there is, of course, those kind of limits in terms of what the companion should be doing, overall, really the companion should be encouraged to be as involved as possible with that limitation. And that's something that the ACAS code also sets out, that there should be that sort of willingness and acceptance from the employer that the companion does have a role in the hearing and therefore should be able to sort of support as much as possible the employee that they are accompanying. As for a couple of other things to look out for in the hearing, then, of course, it's important for everyone involved, but particularly, I suppose, HR, to make sure that that hearing is taking place in accordance with your own applicable policy. The employee is going to have a copy of that policy, so they will be the first people to point out if there's any sort of failings in terms of how you're handling the hearing. It's making sure that the parties are able to put their position across in full, but making sure that it's limited to the points in issue. We often see that particularly crop up when it comes to grievances, where perhaps the scope of the grievance or the scope of the discussion during the grievance hearing goes quite far beyond the issues of the grievance. And it's a real skill to have to narrow the individual's discussions to just the issues that you are determining, whilst also not making the employee feel like they weren't given the opportunity to speak. So really important to just have that in the back of your mind as to how you would address that and keep it on the sort of track that you need to be on. And then finally, as I've already said, of course, the employee's rep should not be allowed to answer any questions that are put for the employee directly. And then back to Kate in terms of assessing the evidence.
So obviously the next phase, which is very important, is actually assessing the evidence that has been gathered as part of the process. So a big question is, how should a decision maker do this? So we've got some sort of key examples up on the slide, and a lot of it is self-explanatory. It's of course crucial to look at and understand the evidence in the round, and make sure all arguments have been analysed, all aspects have been considered before coming to a conclusion. In particular, I'd say it's important to look at technical evidence and whether the decision maker understands that. And we've obviously got quite a good example that's very topical at the minute in terms of the post office processes they went through. What was the technical evidence actually telling them? Was it really challenged? Was it really properly understood before decisions were reached? What we're going to do is just expand on two of these aspects today. And the first is looking at witness credibility and how that should be assessed. So when we talk about witness credibility, what we're talking about is the truthfulness and reliability of a witness and how you can come to a conclusion on that fairly. It can be a real challenge, particularly where you've got a conflict in evidence between witnesses. One person says X, another says Y. Who should the decision maker believe, and how do you justify that decision? So it's important to look at everything in the round, consider a number of different factors. So one would be, what's the relationship between the witness and either the accused in a grievance or the complainant of a grievance, for example? What's the balance of power? Is there one who's another's line manager? Is it as easy for one person to speak up as another? Those sorts of points will be relevant. Also important and a good idea to look at, is there any reason a particular witness may have to lie? Do they have an axe to grind? Is there a particular benefit to them in lying? Because if you have a statement from someone who's got no skin in the game and they've backed up one person or another, that's really helpful in terms of witness credibility and coming to a conclusion on evidence. You can also just look at generally a witness's demeanour when they're giving evidence. Are they consistent? Does it feel a bit over-rehearsed? Do they remember things clearly? Does one thing contradict another that they've said? Have they just got a bit muddled up? All those things are important to look at. And I should also say that credibility isn't really an all or nothing thing. It's not that you believe everything one person says and nothing another person says. You balance credibility of evidence from one witness, and it's basically, who do you believe more on which point and why? And as long as you can justify that, you've done the job in terms of assessing witness credibility. So the other point we just wanted to have a bit of a spotlight on was critically examining the investigation. So something which I think is quite easy to fall foul of as a decision maker is just accepting an investigation or an investigation report as gospel without really thinking about it for themselves. So in an ideal world, you will have a decision maker who is being critical and challenging the investigation and any report as needed. So it's the decision maker's job to make sure that the investigation has been sufficient. For example, is it detailed enough? Did they speak to the right people? If during one witness interview a witness referenced someone else who had some important information, but the decision maker can see that that second person was never interviewed, they need to be picking up on that kind of thing, because it's certainly something that an employee or an employee's lawyer later down the line will pick up on. If there are any gaps, go back and make sure those are filled. It might be that a bit more investigation's needed. There might be some errors or mistakes that need rectifying. Now's the time to do that before you get to the final stage. And vitally, are there any sort of conclusions or statements made in an investigation report that just aren't borne out by the evidence that might suggest some sort of uncritical thinking or maybe even some bias by the investigator? And just a relatively obvious point, but a decision maker's the final port of call for just checking, have we complied with our own policy? As Emma said, go back to basics, look at what we've said we are going to do in the first instance, and just make sure those boxes have been ticked, because it can be an easy thing to rectify, but also an easy thing to fall down on. So once all evidence has been assessed, crucial final step, of course, is making the decision, which Emma is going to talk you through now.
Thank you. So yeah, first things first, of course, actually reaching that decision. And as I said from the outset of this webinar, that is ultimately going to be the panel's decision. It's not for HR to make that decision. It's not for anyone else that might be sort of on the sidelines in terms of the grievance or the disciplinary. It's ultimately going to be the panel or the named decision maker that needs to make the decision. And it will come as no great surprise again that the questions that we need them to determine are those two that I had on the earlier slide. So first of all, are the allegations upheld? And then if so, what is the appropriate action? And it might be that actually some of the allegations are to be upheld or some of the grievances are to be upheld and some of them won't be. And that's obviously absolutely fine. So it's going to be a case of going through each of the allegations and each of the grievances and doing the same analysis in terms of whether it's going to be upheld or not. And how do you actually get to that point then in terms of determining whether you are going to uphold the allegation or the grievance? Well, the tribunal will be looking as to whether you had a reasonable belief that that individual did do what they're accused of. And that is basically looking at it as a balance of probabilities. And that's a slightly lower burden of proof compared to what we see in obviously criminal law, where it's beyond all reasonable doubt. So it is really doing that sort of weighing up exercise, as Kate's explained, in terms of looking at the credibility of the evidence or of the witnesses and reaching your conclusion as to why you favour one version of events rather than the other. In some circumstances, it will be quite simple, quite easy, in the sense that you've got clear evidence that something did occur. But there will be times, as Kate said, where it's a lot more finely balanced, and therefore you're going to have to do a bit more of an analysis as to why you are making the decision that you are making. When it then comes to the appropriate action, again, we often see that there might be a sort of tendency to automatically think, well, I found them guilty of doing this particular allegation. Presumably now I go straight to dismissal. And of course, it might be that that is appropriate. Dismissal is the right course of action, but it's always necessary to consider what the alternatives are before we go to dismissal. And that might be, of course, using your warning system, or it might be a case of looking at redeployment. And that might be a way to give a lesser sanction or try and fix that sort of grievance that's occurred without there being an extreme response of dismissal. And again, if you were to dismiss, there's the option in terms of whether you're dismissing with notice or not. And that's the kind of thing that HR will be able to sort of talk through generally with the decision maker. But of course, it won't be for HR to actually make the decision in terms of what the appropriate sanction or action would be. So once you've made the decision, it's of course then of crystal importance to make sure that that's clearly communicated to the employee. And this is where I kind of always go back to my sort of English GCSE days of structuring your essay in the right format to make sure that everything that's going on in your head is clearly put to paper. So make sure you've got that formula of putting down what your findings of fact are, applying those findings to the allegations, and then giving your conclusion in terms of what that means for the outcome. And that will be for the decision maker to do, so to draft that sort of outcome letter. And whilst I referenced essays, it obviously doesn't need to be as long as an essay. It needs to be quite succinct and clear. And then it will be for HR to review that and make sure that actually the outcome letter is ticking all the boxes in terms of what we would expect to see, addressing every single allegation or every single part of the grievance. But it won't be for HR to actually rewrite the letter and rewrite what the outcome is. Again, think of your sort of English teacher. They wouldn't have rewritten your essay if it wasn't the way that they would have done it. But ultimately, they'd give you tips and tricks in terms of actually, you've missed an important point here. Go away and have a think about it. So without wanting to sort of trigger perhaps bad memories with the red pen coming out, that's kind of where HR perhaps can get involved there. And of course, the other key point to make sure you've got in your outcome letter is the way in which the individual can appeal if they're not happy with the outcome. And that should be clearly set out in your letter too. And that's the perfect way for me to segue to the next session that, of course, we've got on the 13th of March, which is looking at the right to appeal and how to handle appeals. So we would encourage you to make sure you're signed up for that event in a couple of months' time. But for now, if you have got any sort of questions, then please do pop them in the Q&A box. I think there's a few coming in. So just as Kate's having a quick look at those, just a final plug if you are dropping off as it's past, to do our feedback session and make sure that you give any sort of feedback that you have in terms of future sessions or the session that we've had today. We'll just try and do a couple of questions.
Yes, we'll try and squeeze a couple of questions in. If you need to drop off, obviously that's absolutely fine. And if we can, we'll try and follow up on some of these separately as well. So first question I've seen is a question, do you legally need to get minutes signed off, presumably from the investigation, and approved by an employee before making a decision to dismiss, or I guess minutes from a hearing? Short answer is no. There's no legal requirement to get minutes signed off. There isn't really even a legal requirement to take written minutes of a hearing. The reason we always recommend it, and you should do it, is so that you've got a good paper trail of what's been discussed in the hearing, and you can justify any decision based on what's been discussed. Some employers do like to get those minutes signed off. The practical reason for doing so is so that an employee cannot later down the line sort of disagree with what was included and sort of cause issues that way. But it's not a requirement, because equally it can cause issues if you're then going back and forth with an employee trying to change things which you then don't agree with. So it's really a call for which you think is going to be most useful for you in a particular situation, I think.
Perfect. I've seen a few questions as well. Perhaps this can be the sort of last one that we look at in terms of recording the meetings. So, of course, if it was on Teams, it's quite easy now for people to record. There's one question in terms of if there was a request for the meeting to be recorded electronically. Is that sort of reasonable with this employee saying that they have dyslexia and other options have been explored and sort of not deemed acceptable by the individual? Generally speaking, there's not an issue with the meeting being recorded, provided everyone is aware of it, everyone agrees to it. So if this is something that employer is happy to permit, then that's absolutely fine. I suppose the one word of caution with recorded meetings is that, you know, sometimes we see hesitancy of individuals not being quite as forthcoming if they feel like they're in a bit more of a police type scenario where it is being recorded, but in this scenario the employees requested it. Of course, the position is a little bit different if there are covert recordings taking place, and that's where you've really got to make sure you're exercising a lot of caution from both sides in terms of any covert recording. But in terms of reasonable adjustments, it could well be that would be suitable if it alleviates that disadvantage that they're referring to. Okay, should we leave it there, Kate?
Yeah, thanks everyone for attending. Really appreciate it. Here are our details again. If you want to just take those down, as I said at the start, you will be getting the slides. So you should also be receiving these in an email by way of follow-up. Do feedback, and thanks again for attending.
Thanks, everyone.